Hello. Good morning, ladies and gentlemen. I'm Shanthy Weerasekera. I'm the Director of Volunteer Lawyer Service. It's my pleasure to welcome you to this session, Charitable and Nonprofit Primer, as well as to welcome you to Volunteer Lawyer Service. VLS was founded in 1994 as a way for lawyers to give back to the community by providing their services pro bono to small charities and nonprofits in Ontario. Since then, thousands of voluntary organizations have been helped by lawyers like yourself, and as a result, the community has benefited as well. I will speak more about VLS later in the program. At this point, I'd like to focus on the CLE. We have a very interesting session and a great deal of material to cover. This session will give you a deeper understanding of the key needs of charities and nonprofits in Ontario. It will allow you to advise them on how to best establish their charity or nonprofit and how to minimize and manage their legal risk as they deliver their services. We'll also talk about the tax laws that impact on these organizations. We're fortunate to have three prominent members of the legal community, all experts in their field, to speak to you about these issues. You'll also hear from the United Way regarding the very real need in our community for these pro bono services. Our first speaker is Terrance Carter of Carter and Associates. Mr. Carter is well known in the area of charity and nonprofit law. He is recognized as a leading expert by governments, the voluntary sector, and in the legal community. He has written numerous articles and is a frequent speaker on charity and nonprofit law. In fact, I'd like you to draw your attention to a speaking engagement, recent developments on the law for charities. That is on November 10th?
Right.
On November 10th, and there are flyers out there on that. I'd like to draw your attention to that. Mr. Carter has received several awards for his work in charity law, and VLS is extremely grateful that he is here to speak to you today. Ladies and gentlemen, Mr. Carter.
Well, good morning. Nice to be with you this morning, and I'm very happy to be able to share the morning with you with two of my colleagues, Bill Pashby and Jim Parks. We all work on the Ontario Bar Association Charity Not-for-Profit Law section, and we've been doing that now for probably about 10 years, so it's fun to get together with them, both in some of the section meetings as well as helping out today with the program for you. What I want to do today in the materials that you have is talk about really an approach to assisting charities. For both myself and Bill and Jim, we often have clients that come to us and retain us. You're here because you're willing to do so without charge on a pro bono basis. The approach that you need to take really is the same as being retained as a lawyer on a retainer basis. So I want to explain to you sort of the approach that you need to be aware of as you deal with it. And so the first topic we're going to talk about is advising the charitable client. The second topic is dealing with a checklist, a legal risk management checklist, which we used at our firm, and I thought you might find of some assistance as well. You have a hard copy of it in the handout materials, sort of a small brochure that you can use, as well as in the binder that you have from the Law Society as well. The article that's referred to in the binder that you have is probably a little long in the tooth. It's 1996 when I did it, but the first portion of it is still fairly relevant with the approach to assisting clients, advising the charitable client. The second portion of it needs to be updated somewhat, which I'm going to do in the next year. But the checklist that you've been given and what I'm going to talk about, the PowerPoint, is up to date, and so we'll try to head you in the right direction dealing with that. We do have available at our website of charitylaw.ca a bit of materials that you can use as resources. It's free of charge, so if there's some checklist or PowerPoints that you find that you can use to help clients that you're working with, feel free to do so. Now, in the first section, I'm going to talk about advising the charitable client. I want to talk about a bit about the significance of charities, the fundamentals of what a charity is, as well as a not-for-profit organization, some of the challenges in advising the charitable client, a proactive legal risk management approach, and effective communication with the client. Some more details are available again at our website. We do have another website for religious charities that we've launched called churchlaw.ca, and that has some specific information for those organizations as well. Well, the first thing is that charities are really a very significant portion of the economy. And when you couple that together with not-for-profit organizations, they constitute up to 10% of the GNP for Canada. There was a recent report put out by Statistics Canada, just released about 2 weeks ago, that puts the figure at about 9% to be exact. But that's for 1999, and it's felt that those figures probably have exceeded the 9% mark, up closer to the 10%. Charities include universities, hospitals, includes churches, includes community organizations, not-for-profit organizations, although that's not our focus today, includes trade organizations and clubs and so forth across Canada. There are 80,000 charities approximately and 80,000 not-for-profit organizations. It's a huge area of the Canadian economy. And for smaller charities, there's a tremendous need for lawyers to be able to assist them. And thank goodness that there are people that are prepared to do so on a pro bono basis. All of us do our bit where we can, either by writing, or I get many calls that come in, and I always try to assist charities as best I can for some period of time over the phone. You're going to be working with them on an ongoing basis, and that's an extremely important aspect of what they need. What I find is that charities don't understand how complicated the law is, and often lawyers that work with them do not understand that as well. So I wanted to put things into context for you so that you'll have a bit of a background of some of the issues that you need to look at, because what you do on a pro bono basis really has to be the same level, the same quality that you would bring to any aspect of the practice of your own practice. And I think that the approach to take is a proactive approach. In other words, instead of just looking to answer questions that the client has, trying to anticipate some of the issues and try to assist them in areas that maybe they haven't even, they're not even aware that they have legal issues to deal with. So moving from a sort of a benign passivity into a proactive legal risk management approach. Now, before talking about some of the specifics of that, just to clarify terminology, when we talk about a charity, it's a bit of a challenge to try to give a definition to, because there's different definitions depending upon what you look at. If you look at the common law, there's a decision out of England called the Pencil test, which says basically 4 categories: an organization that relieves poverty or advances education or religion, or other purposes that are beneficial to the community as recognized by the courts. That last category really opens it up into all sorts of organizations like Children's Aid Society, community organizations, shelters, and so forth. So that's the common law test. The Charities Accounting Act, which is a provincial statute that deals with charities in Ontario, basically has tried to codify the common law in relation to what is considered to be charitable. However, it's not the same thing as the Income Tax Act. So you have to be careful when you deal with charities. You've got provincial jurisdiction under the British North America Act is given to the provinces, and they have their own definition for it. But when you move into the Income Tax Act, as Jim will talk about a bit further, the definition is a little bit different. First of all, when you talk about a registered charity, it is a defined term, but it's a defined term, not what constitutes it, but rather the sorts of elements that make up of it. Charitable organization, public foundation, private foundation, and so forth. But it does not define what it is the same way that you have under the Charities Accounting Act. There's no definition of what charity is. Instead, a registered charity constitutes part of a larger category, which is called qualified donees. And qualified donees are entities that you can transfer money to and get a charitable receipt from. And they're listed here on the screen before you: municipalities, United Nations, prescribed universities, registered charities, Her Majesty and Right of Canada, or the provinces. Now, the tax advantages of being a charity, and again, just to briefly give you a context for it, first of all, they don't pay tax. All right, they don't pay any income tax or capital gains tax. And secondly, for gifts that are given to them that qualify for a receipt, a charitable receipt can be issued, as a tax credit for income tax purposes. There are some complications that have occurred because of recent proposed legislation dealing with what constitutes a gift, and you need to be careful about that. You now can have consideration involved with the giving of a gift, whereas before you couldn't. The types of forms in which a charity can exist can either be a charitable trust, whereby a couple of individuals hold property in trust for a charitable purpose, or it can be an unincorporated association. A lot of churches, for instance, are like that. Individuals come together, and it's the individuals that make up the organization, but it has no separate legal identity. And so it means that if there's a lawsuit that occurs against a charity that's run as an unincorporated association, you do face the possibility of liability exposure for the members of the organization. And so it's not normally the best route to follow for charity. A non-share capital corporation is a corporate entity, and Bill will talk about that a bit further. It has separate legal existence and does not, though, have share capital status. Now, to flip over just as a comparison, when you go over to a nonprofit organization, there's a lot of confusion in the minds of the public. They'll say, well, I'm part of a nonprofit organization. What they really mean is that they're a charity. Or sometimes they're, involved with a charity, at least they think it's a charity, but really the status is a nonprofit organization, and they don't understand the difference. The difference is a nonprofit organization does not pay tax but cannot issue a charitable receipt for donations that are received. Now, knowing the difference between the definition is important under the Income Tax Act, because it's not a provincial issue, it is a tax issue under the Income Tax Act. We've set out the definition for you of what constitutes a not-for-profit organization, and I think the key thing that you want to keep in mind is a not-for-profit organization cannot otherwise be a charity. If it does qualify to be a charity, it must be registered as a charity, and under that whole regime of having to comply with fairly complicated requirements with CRA. The reason that they do that is they don't want to have, that is CRA does not want to have charities that otherwise should be regulated outside of the system. For instance, sometimes private foundations do not require gifts to be receipted any further because they're well capitalized. And so it's possible that they could have been outside of the regime for charities because they don't need the status of being a registered charity. Well, this definition does not permit that. You either have to be a registered charity if you otherwise qualify, otherwise technically you become taxable. So when you're looking at organizations, you want to see what status that they have, and if you've got a not-for-profit organization and it is otherwise a charity, you may have to move them into getting charitable status, otherwise they might become a taxable entity. So the tax advantages of a not-for-profit are set out there. Doesn't pay tax but cannot issue charitable receipts for income tax purposes. A not-for-profit organization, as opposed to a charity, really has only two forms in which it can exist. One is as an unincorporated association, that's where limited liability is not afforded to the members, i.e. the members do have exposure to liability, or as a non-share capital corporation. What's missing from that is the charitable trust. A charitable trust is a vehicle that's been in place for hundreds of years coming out of our British common law tradition, and that's, at least as far as I can tell, is not available. Certainly with CRA is not recognized either as a form for a not-for-profit organization. So what sorts of organizations fit within that category? Recreational clubs like golf clubs, ski clubs, service clubs, trades associations, and so forth. And there are 80,000 of them. Most times you're going to be contacted to help organizations that are charities, but depending upon how pro bono law works, you might in fact be contacted by a not-for-profit organization as well. Now I want to move into the challenge in advising the charitable client. They're very different. You know, it's very different working with charity. I mean, I really enjoyed. It's been a great privilege to work with them, but they're different, and they're different because they're motivated by what I say the sense of the greater good. But they don't have necessarily longevity. They don't have continuity because there's change of directors, there's change of staff that take place, and so the client that you're dealing with this year could be very different next year, and probably will be different inside of 5 years. And so it means that, if nothing else, you as a lawyer, even a volunteer lawyer, need to keep very careful records, because someone will contact you 5 years later saying, how come we're set up this way? How come we're doing this? And you may recall, well, you had a conversation with the executive director, he or she is gone, or a chairman of the board, and they're gone as well. So it is a very transient type of client. And you have, of course, different commitments. You have some volunteers that are highly motivated with a great sense of commitment, and others that see the position on a board as being just a matter of a really prestige and opportunity to have some recognition. There's often, by the way, some differences of opinion concerning how to structure the governance of an organization, which you don't find in a share capital business corporation. Most times they leave it up to the lawyers and the accountants to figure things out. As long as you make $1, they're happy. Well, in charities, everyone's got an idea about how things should be structured, and so you have to be able to be diplomatic in dealing with that. And the last sort of point is that I find that charities feel somewhat thwarted by the legal process. Somehow the law is there to stop them doing what they really want to do. And lawyers, frankly, are part of the problem. And I think what we need to bring to them is the message that, unfortunately, you have to comply with the law. That's reality. But if you do it well, it can help to facilitate achieving the charitable purpose that they want to achieve. I'm always surprised that there is so little understanding of legal issues by directors and by staff. And one of the things that is going to happen, I think, over the next 5 years, CRA, and I have an opportunity, and other lawyers do as well, to give them some sort of suggestions and directions on various volunteer committees. What we're recommending to them is they need to be part of the process to educate the volunteer directors. They need to get information out. They need to provide manuals to them. They need to provide handouts and so forth, because volunteers who come on to these boards want to serve. They want to help out, but they don't have a clue about how to comply with legal requirements. Well, until that becomes more of a sort of a universal context for governments in assisting volunteers, we as lawyers, I think, have a job to get information out to charities and directors so that they'll have a general understanding of the legal context. Now, I find that often charities have an unrealistic expectation of what a lawyer is to do for a charity. First of all, they normally want you to do services pro bono, and which you're prepared to do, which is great, or they'll want it on a reduced fee basis. But what they want is expertise that sometimes is unrealistic. And what I find is that a client who's contacted you about A will assume, because they've spoken to you, then everything from B, C, D right through to Z, they assume that you've given your seal of approval for. I mean, heaven help you if they send in documentation to you. They haven't asked you to review it, but you have it in your file, and they say, well, you saw it. It must have been okay because you didn't tell us that it was a problem. All right? So lawyers are seen as sort of seals of approval. My lawyer knows what we're doing, and he or she hasn't said anything, so it must be okay. And this has happened many, many times to, at least in my own practice. So I think you have to be more cognizant of the client's reliability on contacting a lawyer and the fact that it is seen as a seal of approval. And that means that you need to be proactive in putting the responsibility back on the lawyer. Now, my experience is that charitable clients often to get into difficulties, and again, that's what we're here for, is to try to help them not to get into difficulties because of the following. First of all, the complications of the statutory requirements. You've got the Income Tax Act at the federal level, and you've got fundraising under the Competitions Act, you've got anti-terrorism legislation, a number of different things, the Privacy Act federally, and then provincially you've got Charities Accounting Act, Charitable Gifts Act, you've got a number of different provincial statutes, because a charitable client at the end of the day, by the way, is just a type of client with all the needs of any other type of client, whether it be contract or tax or employment or otherwise. Employment Standards Act. So there's just a myriad of different statutory parameters that they have to work with. Next is that there's increasing exposure of directors and officers to liability. It's unfortunate, it's wrong. I think if we look to the American experience, we're seeing that there's more protection being given to directors of charities because the public is demanding that. It's ridiculous to recruit volunteers and expose them to liability. We need to give them statutory protection, but we're not there yet, maybe in 10 years from now. The complications of the Income Tax Act, I had my copy here somewhere. Draft amendments just came out September the 16th. They're very, very complicated. There were draft amendments back in February of this year, which are very, very complicated. I don't know how directors of charities and executive directors can keep up with the changes unless they've got, accountants and lawyers that are by their hands helping them. So the complexity of the Income Tax Act is making it more challenging for them. As well, the fundraising aspect of what charities do, which is their lifeblood, they have to raise monies, is now becoming highly regulated in a number of different provinces. We have legislation in place. There's a task force with the Uniform Law Reform Commission of Canada with Professor Oosterhoff, which is doing a review of it to come up with proposed standardized legislation. So that's on the horizon as well. In relation to management of gifts that come in, there's complexity involved with proper tracking of gifts. There's issues of operational risk. Sexual abuse of children is unfortunately a reality, and there's a high level of concern by directors concerning that. And then if you have charities that deal overseas, they do have to be aware of some of the possibilities of liability under the anti-terrorism legislation, which, by the way, is up for review this fall. Issues involving investments. There are regulations or provisions under the Trustee Act of Ontario concerning what applies there. Sometimes there are complicated organizational structures. For instance, you may have a local chapter. Is a local chapter a division of a larger single corporate entity across Canada? Or is your local chapter a separate legal entity unto itself? What's the relationship between the two? What about the flow through of liability up to the national organization? So there are issues with organizational. Employment issues are huge for not-for-profit or for charitable organizations. And often it's not well documented. There's no employment contracts in place. Privacy issues are a factor because, generally speaking, charities assume that they're exempt from it, and they shouldn't if they fall within the definition of commercial activities, which is very broad. They probably generally are caught, but even if they're not, industry standards still, I think, would dictate that they want to look at privacy policies. And normally a lack of adequate contractual documents and a lack of history of documentation. An executive director goes, sometimes that executive director will take the documents. Or a treasurer, a volunteer treasurer, will have boxes of materials down in their basement and will not hand it on to a successor in place, so there's no history of the organization. Well, some of the consequences that they need to be aware of that come from deficiencies in structure and operations. There can be legal actions by donors and by the Public Guardian and Trustee of Ontario, disgruntled donors. And as our generation, include myself in this, the yuppie generation becomes more concerned about where mom and dad's money is going, they start to ask questions about estate gifts that are given through estates, and therefore we're starting to see some challenges. Allegations of breach of trust, which is a very difficult thing, of course, for directors of charities to deal with. If they're coming on as volunteers, why would they be faced with allegations of breach of trust when they mean well? Well, unfortunately, even for unintentional matters, they can be found in breach of trust, particularly under the Charities Accounting Act. Loss of charitable status is more of a concern now with the changes to the Income Tax Act. There's confusion in corporate operations. Loss of corporate status can occur. Sometimes directors, which Bill will talk about, can be involved in activities that are not authorized by the objects and so forth. So lots of problems. And I don't mean to overwhelm you, but you need to understand that you need to be aware of the context of the problems that they can get involved with so that you can sort of calmly explain some of the issues that they need to look at. Now, in relation to our role as lawyers in assisting a charitable client, my experience is that not only do they not know the answers to the questions, they don't even know what the questions are. All right? So it's kind of up to us to start putting some questions in their minds, and that's why the checklist which I gave you is just a tool. It's not comprehensive. It's not a guarantee, but it's the sort of thing that you can work with. You can say, by the way, have you thought about this or that, and to help them through that thinking process. Now, when you talk about it, of course, you have to explain what the problem is and how to deal with it and what some of the risks are. And if you don't, unfortunately, you do get some exposure to liability. Now, what are some of the conflicts that you can have as a lawyer? I'm not talking about the directors. Bill will talk about that later. But some of the problems that you can have, well, first of all, in Ontario, if you're a member of a board of directors as a lawyer, by all means, you can give all the free advice that you want, but you can't charge for it, all right? Can't do that. That's because of the decision of the Toronto Humane Society decision a couple of years ago, back in 1987. If you are giving advice, and you're a volunteer member of the board, then the advice that you give is separate from the role that you have as a director of a charity. So you want to distinguish between the two. I would think if you're going to be on a board, you're there as a board member, and you should be advising the board that you're not there to give legal advice. If you are, make it clear, set up a retainer and so forth. But to be asked on the spot to give advice at board meetings is not fair to you. The charity should be retaining legal counsel. Or you can come off the board and you can provide free legal advice to the organization. But to combine the two, I often find is difficult. Sometimes you're called upon to act for two charities, sort of related charities, maybe a hospital and a foundation or something like that, and there are potential conflicts that you have to stay clear of as well on that. And sometimes, the advice that you may give to the executive director is clear, but the executive director doesn't really want to accept it. That's fine, but he or she doesn't want to necessarily pass that on to the board of directors. Well, your responsibility is to the board. And so sometimes, if you don't think that the information is getting through to the board, I think that you do have to look at communicating directly with the board of directors. Doesn't make you very popular with the executive director, but you really don't have any choice if the information is being held back. So the sort of approach that I suggest is sort of a legal risk management, a proactive legal risk management approach, recognizing that we're more than technicians, going from passive into a sort of a proactive preventative mode. And it really means that you as a practitioner need to be kind of a jack of all trades when you go in to help these organizations, a bit of corporate, a little bit of tax information, something so that you can be a generalist to be able to point some issues out for these organizations. And you need to get facts. You've got to ask questions because, again, they often don't have a lot of institutional history. So an example would be, what are your objects? Bring me in your letters patent. Often they don't know where to find them. Do you have any supplementary letters patent? What's that? And if you do have supplementary letters patent, is that all there is? I mean, how many times have you changed your objects over the years? So you want to do like a corporate file search because you can't rely upon the information that they give you. You have to kind of dig deeper. So doing a corporate file search it's not even that expensive to do. You'll have the information there. Get the corporate minute book, take a look through it. Now, when you're meeting with the client, you're talking about the issue, again, maybe ask them a question A, but you may have some other related issues. You need to identify the issues, point out the consequences, give some general idea of what they should do, and then you want to try to prioritize the work that they should be addressing to deal with the problem. And I highly recommend, and again, even as a volunteer, document your recommendations, even a point form memo, anything. Because the person you're dealing with today may not be there inside of 2 or 3 or 5 years from now. And if you don't have it in place, you're not going to have any protection from liability. And you want to place the onus clearly on the client. Here are the issues, here what you should be doing, here's the prioritization. Now get back to us what you want to do. And sometimes if there's been a change, particularly of executive staff, you'll want to get back and be proactive to get hold of the new executive director to talk to him or her about some of the issues that were left outstanding by previous executive directors or by the directors themselves. And then the idea of using a checklist, and again, whatever works for you, the sample given to you is just that, a sample, but it helps to direct your mind as you go through it, and helps the client to focus on some of it. I normally give a copy to the client, keep a copy myself, make some notations on it, provide a bit of a report to the client afterwards, and offer to hold subsequent meetings to follow up. The communication with a charitable client, I think, is very important. Again, because their memory is short because of the change of staff, poor record keeping, and I don't throw out, by the way, any of my files. I got charities going back to the 80s, early 80s, and I'm glad I've got the file to pull up because they often will say, how come we did this, and would otherwise suggest maybe that the lawyer did something wrong, and I like having that record in place. Confirm the retainer what you're doing and what you're not doing is very important because, again, they'll assume often a lot more than what you're planning to do. And I find that the report's a good opportunity to be educational. You can cross-reference the tools available free of charge on the website. We've given you a copy of Chapter 6 out of the Director's Primer prepared by the Canadian Bar Association, Industry Canada, and the Canadian Centre for Philanthropy. It's just an example of some risk management steps that charities and directors can take to protect themselves. When you become familiar with some of the links on the website, you can say, go here, there, and so forth. Take a look at some materials. So your report can be of educational nature. And again, you want to, with your report, prioritize the work to be done. And if you're going to undertake work, you need to be realistic about the time frame. I often find that the client has unrealistic expectations of when you're going to do it. And it's not fair, of course, as doing work pro bono, that you drop everything else in your practice to do that. So that's a bit of an introduction with advising the charitable client. And now I'm going to see if I can do this like that. Good, success. Now the second topic that I want to cover with you is dealing with due diligence, lawyers' due diligence, which really is sort of a walkthrough of the legal risk management checklist that you have before you and some of the issues that you may be called upon to talk about. Generally, most of you will be contacted to get them charitable status. All right? The material here does not address that much. One, because Jim Parks is going to talk about it. Secondly, because the process is often fairly straightforward. You can go to the website of CRA and sort of walk through the application form and so forth. What I'm talking about here are some of the other related issues that you'll find that you need to look at. The possibility of using multiple corporations, board management issues, and so forth. So these are a list of some of the topics that we'll talk about. If you're looking for more information on these topics, you can go to our website and get some materials on it. Well, in relation to identification and management of legal risk, first thing is to look at, do they in fact need charitable status? Client comes to you and says, we want to be a charity. Why? Sometimes it's a husband and wife who want to set up an organization, and they don't understand that everything that goes into the charity will be the property of in essence, the charitable trust, as opposed to something that they own themselves. And is there anything that they want to retain on their own? Is there some intellectual property, for instance, that they want to retain and license over? Do they in fact need charitable status? If they're going to get monies from businesses, they don't actually need it. But normally corporate donations require the status of having a charity involved before they'll give monies to it. Sometimes they can work through an existing charity. It'd be a division of one. Why go through the expense and the trouble of setting up a new charity if they can work with an existing one as well? Now, if the organization is already in place, you do want to look at their current legal documentation and do an inventory of their key documents to make sure that you understand how it is that they operate. If they're unincorporated, you look at their constitution, make sure you have copies of all of their amendments, policy statements of how they operate, because they can all impact how you structure the incorporation documents to become incorporated and get charitable status. If they're incorporated now, my experience is that normally their corporate records are the pits. They won't have a minute book, or if they have a minute books, the secretary's got it and they don't know where the previous secretary is, or maybe the lawyer that set it up in 1987 has it, but he's now out of business. So no one's got the corporate records. So you have to find where they are, and they have to rebuild the corporate records if they're currently not in place. The types of things that you want to look at is documentation to establish what membership is, the bylaws, the resolutions, list of directors and members, and copies, of course, of government filings, which normally are non-existent. And then look at some of the other documents that they should have. If they have leases, copies of the leases, they own property, deeds, they have contracts with other organizations, particularly outside of Canada. You want to look at association and agency agreements. And if they have license agreements to use certain names, or they've allowed their names to be used by other organizations, you want copies of that as well. And some other examples of documentation that you want to get is, their policy statements, their status with CRA, if they have any trademarks, insurance policies. Get a full array of their corporate documents really to do an initial legal audit for them. Now, when you're looking at an unincorporated association, what you want to do is see if their objects in their constitution are in fact exclusively charitable. Sometimes the organizations are fairly old, and they may go back to the 70s or the 80s, and what they have in their constitution may not match up with what's considered to be charitable in accordance with CRA requirements. So sometimes you have to amend the objects. The trouble with that is, if you start to amend their objects and send it to CRA, it's like a Pandora's box. You start asking CRA for permission to change their objects, then all of a sudden they're asking all sorts of questions. So you need to see if they're off base, but then you need to see practically, do you go and try to expand the objects? And if you do, you have to explain to them that CRA may not find it acceptable. Even if the objects don't need to be changed, have they ever properly filed copies of the Constitution with either CRA or the Public Guardian Trustee of Ontario? And the PGT has jurisdiction over charitable property in Ontario. So every time that you have a new charity in place or change its bylaws, whether it's incorporated or not, you have to send in a copy to the PGT. If the organization you're dealing with is a corporate charity, then you want to go through the process of reviewing, which Bill will talk about a bit further. Check the objects, check its name. By the way, often the name of a corporation in its corporate documents do not match up with the name that they operate under, and they've never done a business name registration. So, they've got exposure to liability. It's a very serious matter. And just on that regard, if they're operating in other provinces, they have to do extra-provincial registrations in other provinces, and may have to do business name registrations in those provinces as well. So looking at the whole name, the corporate name issue is important. The objects, of course, to see if they continue to be charitable, and to make sure that they're broad enough to be able to encompass all the activities. Review the supplementary letters patent, and Bill will talk about this. Letters patent of amalgamation in Ontario to make sure the two organizations both are charitable. And take a look at the bylaws, and again, Bill will talk about that. You want to just make sure that you're checking through. Do not assume just because they have a general operating bylaw that it's okay, because the law in Ontario has changed. The Canada Corporations Act is in the process of being changed. The status quo normally, 99% of the time of organizations I've seen is not adequate. They need to do something to bring it up to date. Whether they want to do it or not, that's up to them. But you need to be there saying, by the way, you've got the following inadequacies with your documentation. Looking at some of the corporate filings that need to be done. If it's an Ontario corporation, of course, they have to do their Form 1 notice of change every time you have directors and officers change. Business name registrations if they're operating under a name different from their corporation. Making sure the PGT is up to date. No one is going to go after them saying, by the way, you haven't done this or that. No one's going to remind them. All right? It's up to them to do that, and it's up to you to remind them that they have an obligation to do that. If they're incorporated under the Canada Corporations Act, then they do have an annual summary requirement, and that is sent out by Industry Canada each year as a reminder. But they have to have an extra-provincial license in Ontario, and again, business name registrations have to be done in Ontario. They're involved in fundraising. Fundraising in Ontario does not require registration, although the courts are very proactive to interfere if there's fraudulent fundraising taking place. But in other provinces, Alberta, Saskatchewan, Manitoba, PEI, there is legislation in place, and they will have to register and comply with that requirements. There's a paper that one of the lawyers at our firm did that talks about sort of a chart of different requirements in different provinces, and so that's available as a reference tool for you if you have charities outside of Ontario. Looking at policy statements, risk management. Do they have a child abuse or sexual abuse policy? Sometimes they do, but sometimes they'll get it as a photocopied version from someone else, or maybe an insurance broker has suggested it, and it hasn't been customized for the organization that they deal with. Well, an inadequate policy is sometimes worse than having no policy at all, particularly if it's unrealistic in relation to the expectations that it puts on the charity. So reviewing and commenting about the practicality of that is important. Safety in the workplace is a huge issue. A lot of these organizations are getting volunteers to go out to do runs and going out to do various projects. What do they have in place in relation to provincial workplace safety requirements? Because there are now problems, which I'll just mention now, of not only civil liability, but there's problems now with criminal liability under Bill C-45. That was the Westray Mines amendment that came through earlier this year that basically says, if there's huge gross negligence, it isn't just a civil matter, now is potential criminal liability. So you're going to have volunteer directors involved with a work program in Canada or maybe overseas that are now facing criminal liability, not just for the organization, but for the directors as well. And that leads into a question, well, do you have insurance? Do you have insurance to cover potential criminal charges under the recent amendments to the income tax, to the criminal code? So those sorts of issues and operational policies need to be reviewed because, again, any lawyer that's involved with the charity is perceived as saying everything's okay. And so it's important to point out some of these issues for them. Issues involving use of multiple corporations. Most of us here as lawyers wouldn't think twice about saying to a business client, let's contain some liability and let's have multiple corporate structures. So for each project that you do, you go 1, 2, 3, 4 Ontario Limited and so forth. For charities, it's the same thing. Although they don't think in those terms, if you've got major assets in one charity and you're going to go into a new venture that's got high risk, why run it through the same entity? Run it through a separate charitable corporation to contain the liabilities and to protect the assets. So it's becoming more frequent that charities will have two entities. And also for fundraising. If you're going to have a major charity that's got that has a fundraising initiative to raise funds for endowments for a long-term purpose, to have those funds held in a separate foundation, given recent case law like the Christian Brothers, is important. Because if you keep it inside of that charitable organization, it's no longer protected as a sort of a restricted endowed fund. You've got to put it into a separate entity to get the protection that is needed. But when you got two organizations, you got to be careful because if they sort of operate as one sort of thinking mind between the two, the courts reserve the right to look to see if there can be some crossover liability. In other words, you have to have an arm's length relationship between the two. You also want to look to see if you're going to have some control that you can do indirectly, maybe through licensing. If you've got a charity that's got a good name and it's going to allow that name to be used for another corporation, you can license it as a trademark, sort of like a franchise, and have very effective control through a licensing arrangement without having to have more overt control through the governance structure. So those are issues that you need to look at. Board management issues are a major factor. who in fact is running the organization, right? Because the courts hold, as Bill will talk about, the director's liable, but who are the directors? Sometimes in a church they'll have a board of deacons, a board of elders, a board of management. They all may collectively constitute the board of directors for liability purposes. Or sometimes an organization, large ones, for prestige purposes, will have a board of 42. I've got one client with 42 people from across Canada. They have an executive committee of 8. And really the executive committee runs the operations. But those poor 42 people are as exposed as the 8 because they want to have the recognition as being directors. So you need to sort of evaluate on a de facto basis who really constitutes the board of directors and see if there in fact is responsibility that's in place by the directors and not by the executive staff. A lot of discussion about the idea of the board establishing policies, which is great. You want it. But you don't just sort of say, here are the policies to the executive staff, now you run it, and it's your problem. The board has to have continued supervision over the operations of the charity in accordance with the policies that have been established. So there needs to be a proactive involvement with the board. You need to have an audit committee in place. You need to have both for legal risk management as well as financial matters. You need to watch over communication that's in place between the executive staff and the board. And again, I just stop here. It's not your job to go hunting for these problems. I'm not suggesting that you have to do all of these things, all right? But what I'm suggesting to you is that if you have sort of a knowledge base of this, you may find that there are some inappropriate things that are being done. An executive director that runs the whole organization and once or twice a year he reports to the board of directors, that's not adequate. And that message should be communicated in a tactful way over to the board. Reducing board liability, again, there's a chapter 6 that I've given you out of the director's primer that gives you some idea of it. One of the things that you want to look at is there an indemnification bylaw in place? Hopefully there is. Has the indemnification bylaw been done in accordance with the Charities Accounting Act requirements? And that often is not the case. There are now some statutory requirements that have to be looked at. The same thing for directors and officers' liability insurance. Until 2001, believe it or not, charities could not buy directors and officers' liability insurance or pass indemnification bylaws for directors and officers without court approval. Ridiculous. So that was changed by amendments to the Charities Accounting Act, and regulations were put in place. However, most charities do not look to see if the requirements of the considerations to get the authority to do that have been looked at. For instance, if you're going to buy D&O insurance and the operating budget of a charity is $10,000 and D&O insurance costs $3,000. I mean, is that reasonable? Probably not. If a charity has $1 million budget and it's a $10,000 D&O policy, it might be. So those are the factors that you have to look at, and you need to be aware of what those requirements are. Sometimes directors are quite worried, and I think they should be, about liability exposure. Well, one thing they can do is reduce the number of board members and expand the number of committees. Get the work done, but the committees are responsible to report to the full board of directors. So you can have the same effective number of volunteers at a high level involved, but not all of them have to be directors, provided that they're prepared to have the lower status of a committee member. But frankly, there's a lot to be said to being a committee member and avoiding the liability exposure of being a director. So the size of the board, size of committees can be looked at. Sometimes it's important when you're advising the charity that you distinguish between your role in acting for the charity and the role that you're not doing, i.e. you're not giving advice to the directors personally. Where you have a high-risk situation, you need to be able to say, my advice to the charity is as follows. And you can say, potential liability for the directors is as follows, but I'm not giving you legal advice. You need to go off and hire another firm to give you advice as directors on a personal basis. And normally what they'll do is hire one lawyer for all directors, but that needs to be done because what's good for the charity may not be good for the directors themselves personally. And so you need to be able to draw that distinction. Now, just dealing briefly with insurance considerations, really important that they keep track of the number of policies that they've had over the years because claims, as we know now with sexual abuse, can come up 5, 10, 15, 20 years afterwards what policy was in place. Need to look to see if there's occurrence-based insurance or claims-made insurance, huge factor in relation to sexual abuse. You know, claims made is like our D&O insurance. If a claim is made in the year 2004, you're covered, but if a claim is made outside of that period of time, there's no coverage. An occurrence-based means that, well, I'm on the board in the year 2004 and there was an alleged incident, alleged occurrence. Right? There's coverage no matter when the claim is made. And so all insurance policies dealing with sexual abuse maybe 5 or 10 years ago were of an occurrence-based nature. Now what they've done is taken sexual abuse out of occurrence-based and now put it into separate endorsements and are selling it as D&O insurance for directors dealing with sexual abuse. But the trouble is, if you're on the board or your client's on the board today in 2004 and you've got claims made, you really hope that they're going to remember and can afford and can get insurance in future years. Otherwise, 5 years from now, when a claim comes up for an incident in the year 2004, there's no coverage in place. So, you know, knowing the type of insurance that the charity is getting is very important. What my recommendation is, take the liability of insurance and download it to the broker. All right? Get your charity to give a full report over to the broker of all the things that it's doing, all the activities, details, everything, annual report, the whole thing. And then ask the broker to provide a report in writing saying, what coverage do you have? Right? Who's covered? Is it, you know, directors, officers, members, volunteers, and so forth? Right? Who's not covered? What risks are not covered? And then, what recommendations does the broker give to improve the coverage? Now you got detrimental reliance. Now what you've got is a broker that's giving you advice, and if it turns out it happens to be a bad policy, you actually get an extra layer of insurance coverage to look at. You know, they're making a fee. They're making a profit. They're professionals. They should, I think, be put to account. And you may need to look at a number of different special endorsements that you have to get. For instance, if you've got even a local church that sends their kids over to help in Haiti over the March break, a lot of churches do that. Do you have any insurance coverage? Probably not, because it's restricted just to North America. So all the activities that your charity is going to get involved with, you need to ask the question, do you have insurance coverage in place? Is it adequate? No, is the quantum of insurance adequate? A lot of charities have $2 million policies, but they're dealing with kids, and there's no way $2 million is adequate. Insurance companies like to sell, you know, 100 $1 million policies instead of 10 $10 million policies. It's a better risk factor for them. So the broker won't necessarily say get more insurance. You need to give that some consideration. Third-party use of charitable property, if the charities are allowing other parties to use it, is there an indemnification agreement in place, right? Shifting the risk over to the third party? Is there appropriate insurance in place by the third party naming the charity and its directors and officers as named insureds? And does it have adequate insurance, or put differently, is it going to cover the type of risks that need to be addressed on it? Take a look at the real property issues for your charity. Sometimes older charities, particularly churches, have really complicated and problematic trust provisions that are outside of the 40-year rule and qualified land titles, but those trust provisions still apply. So some of the old churches that you have, you need to look to see if there's restrictions there in place. If you have charities that are holding property for more than 3 years, you've got and it's being used for commercial purposes, rented out, you may have issues under the Charities Accounting Act. Intellectual property issues, part of what I do is, and it's sort of happened over the last 10 years, I'm a trademark agent because the most important asset for charities, I've found, is its name, its reputation. That's how it gets gifts. That's how it gets estate gifts. And charities are now starting to wake up to that. One of the clients that we deal with internationally has had the value of their intellectual property put at $1.8 billion. It's huge. Not every charity is going to have that, but now what's happening is that charities are seen as a source of separate funding that they can get through sponsorship agreements. Look at the Canadian Olympic Association. Look at some of the organizations that are sponsoring products for sale. There's goodwill factor there that has dollar values, but often charities have not taken steps to have that property protected and licensed. So that's something that you can look at is both trademarks and copyrights. Has there been adequate protection for it? Has there been adequate protection even of its internet domain names? You know, Microsoft.com has a great deal of value as a trademark as well as a domain name. There's some materials on our website that talk about that you can use as a reference tool in talking to your clients. Employment matters. It's a whole separate topic. It's not for today, but my experience is that it is not well addressed, not well documented, and the greatest problem probably that charities have are dealing with wrongful dismissal claims. So you need to be looking at what steps you can take to try to reduce that in the same way that you would with any client. And I just point out to you that liability exposure that we talked about a bit before, but Bill C-45, the Westray Mines, not only applies to volunteers, but applies to employees as well. So if employees are involved with a high-risk event, they have the potential of causing criminal liability exposure for directors as well. Now, I think what I'm going to do, I want to stay on time here, just highlight some of the things that are here. I won't go into detail on it. There are some longer articles at our website that talks about fundraising, some of the liabilities. One that was recently posted in April of this year called Looking to Gift Horse in the Mouth that you can make reference to. Fiscal management issues. Frankly, a lot of charities run at a deficit, and you can't run a deficit for long without getting into liability exposure for directors. And so you need to look at how to address that issue. Sometimes charities are involved with running businesses on the side. The Charitable Gifts Act gives restrictions to that. Can't own more than 10% for longer than 7 years. Investment issues, prudent investor rule applies, and if they're delegating down to investment manager, you have to look at the requirements to do that, whether they've got an investment policy in place. Donor restricted charitable gifts. The whole area there, it's kind of like a charity within a charity. You can have lots of breach of trust when building funds or endowment funds are inappropriately used or borrowed against. So there's an article, again, at the website that gives more details on that. Charitable registration, Jim will talk about that in a bit more detail, how to get the charitable status and then how to maintain it. And just to point out, the rules are all being rewritten. Everything that we knew is just about being turned upside down because of amendments that came through in February and September the 16th of this year. So it's quite different. If your charity fundraises in Quebec, you've got to get a Quebec charitable registration separate from the federal one, although it's very similar to it. And look out for rules that deal with related business activity, political activities. There are a lot of rules that apply to it. The website of CRA is very extensive, and it's the place to go for information dealing with the Income Tax Act, CRA website. And if you're involved with national international relationships, it needs to be well documented. To skip over that. And of course, my favorite, because I got a website on this, anti-terrorism law is an issue. It's a bit of a sleeper. It hasn't come out to sort of bite charities yet, but it's there and it's quite extensive and could be a problem in the future. So I think at that point, what I'll do is just take a couple of questions. Is that the idea?
Questions. Okay. If there are questions now for Mr. Carter, please go ahead. We're going to have to limit it to about 5 minutes, and hopefully some of his questions can be answered.
And I'll stay at the coffee break as well.
Thanks.
Yes, sir.
Questions. Charity A is operating. Can it form an organization to carry on business under B charity? Will B charity also have to apply to CRA for charitable status? Question one. Question two, you mentioned about acting on a committee of a charity. Not a direct act on. Are
second question, it's the easier one of the two. An individual who's on a committee should not be exposed as a director, provided that that committee does not take on the de facto role of being directors, making decision-making. As long as the committee defers to the board of directors, I think that they're fine.
Committee report back to the board.
Absolutely, absolutely. The first question is, can a charity A run a business indirectly through entity B, and does entity B have to become a charity? Is that the? Sorry, I misunderstood.
Say it's incorporated under one name, and it's not a name that they feel is attractive for raising money.
Oh, I see. Okay.
They don't want to change. So they use the second name to be their fundraising arm.
You can do a business name registration. So you got ABC Charity, and it's operating as 1, 2, 3, 4 charity.
Yes. Does the business registration require a charitable registration?
No. But you do have to, under the Business Name Act, register, and you have to advise CRA that you have an operating name, but it doesn't have to be a separate number on that. So, okay. Yes, ma'am.
I understand that CRA is changing a little bit in terms of review of declined charitable status. Could you comment on that a little bit, how that works if a nonprofit organization has and is declined in the first go-around, there is some kind of a new review process?
Right. That was as a result of the JRT, the Joint Regulatory Commission report that was given to the government and then was included in the March 2004 budget, which now is in the legislation September the 16th. And basically what happens is if you get turned down, there's going to be an internal review process that you'll be entitled to before you have to appeal to the Federal Court of Appeal. Which no one wants to do. And very, very few charities can afford to do that. I mean, if you get turned down, you got to have a real reason to want to spend, $100,000 to go to the Federal Court of Appeal. So this process is supposed to make it more practical for smaller charities for them.
Is it more arm's length than the current process?
Yes.
Coming from direct experience.
Yeah, well.
When the review has been done by the same person who declined in the first place.
Yeah, no, and I've been there too with you, I understand that. Time will tell, but that's the intent. Otherwise, it's a waste of time. But that's the intent. Yes, ma'am.
You mentioned earlier on that one option might be for a group to operate within an existing charity.
Right.
What would be the pros and cons of choosing that? Are there any particular concerns that ought to be addressed if a group comes to us and says, well, we want to raise money for our library grant, but
Right.
we could be do it through the whole library system?
Right.
Charity.
Right. Well, the pros are it's a lot of savings and cost, time, and exposure to liability because you've got a corporate entity in place and their own board of directors. The downside is you don't have control. So if your group wants to do their own thing on their own terms, they lose that. What the operating charity, the umbrella charity, would have to do is make sure it has the corporate objects to undertake this particular program. And secondly, that the board would have to, in fact, say, yes, we're now doing this program and take responsibility, include the activities in the financial statements. It's basically an expansion of the organization's programs to include it. So that's practically what has to be done.
And can you have some kind of agreement with the, because you're not really incorporating group, but can there be some agreement that would bind the greater charity to some use of money that you might raise or something?
Well, I mean, if you're going to come in with a turnkey program, one would assume that you could negotiate some terms, sure. But once you're under the authority of that charity, you're part of that one single legal entity, and unless within the governing structure, you basically it's like it's a merger, an acquisition. I mean, what you've got is an acquisition by the bigger charity of this new program, and as you go in, try to get the best governance structure that you can. But after that, you're subject to the full authority of that board on that. So, okay, yes, ma'am.
You mentioned chapter 6 of the director's primer.
Right.
I didn't get the publisher.
Okay, that's put out by Industry Canada, Canadian Bar Association, and Canadian Centre for Philanthropy, and you've got the excerpt in their materials. If you go to, for the link, if you go to our website of charitylaw.ca, and it's got a search engine, and type in Director's Primer, it will take you to the link. Okay? Okay. Okay? Yes, ma'am.
The
just to repeat that, what can you do in structuring a bylaw where you've got a powerful executive committee to make sure that the full board of directors continue to have some responsibility and some protection from liability from the actions of the executive committee, right? Okay. And what you want to do is make sure the executive committee have parameters of what they can do and what they can't do when they're meeting. Secondly, you want a requirement that they're going to be reporting back to the full board of directors. Third thing is that you want to make sure the full board has the ability to remove, replace, and to amend the parameters in which the executive committee is acting. So if you've got a rogue executive committee, the full board can say enough is enough. So that all has to go within your governing documentation, your bylaws. Okay. Okay, and I think there's one more.
Last question?
Yep, one more. Yes, sir.
I understand that the premiums for directors and officers liability have increased significantly
Yes.
in the last few years.
Right.
Actually, my search is for actual standard of care is limited to directors and source deductions, I guess, and they're very limited in Canada. Are there things I'm missing in Canada, or is it the U.S. experiences pushing these up?
No, it's the Canadian experience. And Bill's going to talk about the directors in office, so he'll talk about the specifics of it. But what I can generally say is that there's more legal action against directors than there were before, because normally charities don't have much money, right? So there's going to be a lawsuit. You know, you normally throw the broader net and include directors, and there's lots and lots and lots of liability exposure. Again, Bill's got some materials. I've got some material on the website that talks about the extent of it, and it's there, very there. Okay, good.
Thank you, Terry, for that very comprehensive look on charitable issues. Our second speaker is Mr. Bill Pashby. Mr. Pashby is a partner in the Toronto office of Borden Ladner Gervais. Mr. Pashby's expertise in the area of commercial law, and he advises a broad range of businesses and organizations, as well as the charitable sector. He's an expert in the area of charitable and nonprofit law, particularly in the fields of incorporation and obtaining charitable status, and on governance issues. He's the national chair of Borden Ladner Gervais' not-for-profit practice group, and he's a well-known speaker in the charitable law field. And VLS is very appreciative that he's here to speak to you today.
Good, thank you very much. Nice to be here. A lot of people ask me how I became involved in charities, and it probably surprised most of you, but I started off practicing law doing securities deals. Some people say I saw the light, or maybe the market changed, but in any event, I don't do securities deals anymore, although it's funny, a couple of my charity and not-for-profit clients are sort of involved in that business. How many here took business org in law school? Hands up. Those who didn't? Okay, good. You're about to get the course. And from guessing the age of some of the people here, it's maybe been a while for the people who took business org. If you took, I'm a sort of a corporate lawyer by background. That means I have in my, beside my desk, I have the Canada Business Corporations Act, the Ontario Business Corporations Act, the Canada Corporations Act, and the Ontario Corporations Act, which really caused me to get very confused in many cases, so I actually have to look up a lot of things. But for the purposes of charities, they're all incorporated under the Ontario Corporations Act or the Canada Corporations Act, and they have some differences. So if you did take business org, you probably spent 95% of your time on for-profit corporations with shareholders' rights and things like that. So I'm going to start off here by giving you a little bit of a background difference between the two, and then you have to, from the corporate law point of view, change your mindset substantially. Every non-share capital corporation, which all charities, or 90% of the charities are, should have a minute book. And as Terry mentioned, when we get a new client, I always ask to take a look at the minute book, and less than 50% of the time can the client ever come up with a minute book. And we have devised lots of ways to dealing with those circumstances. But the minute book should contain the letters patent, so that's the term you use for the charter, and in the letters patent they set out the objects. And again, if you're taken business org in the last 25 years, you won't have to worry about objects for non-share, for share capital corporations, but objects describe what the objectives of the organization are. They also have to have in the bylaws, and there will be a general bylaw which will set out rules for calling of meeting and how many directors are going to be, and it's sort of the constitution. There should be minutes of the members' meetings, minutes of the directors' meetings, and there should be a register, which is a list of the directors and the members and the officers, and probably copies of the government filings, which have to be made usually annually. Now, there's 3 statuses that I think you should be concerned about and know about for your nonprofit clients who are incorporated. At the top, there are members. And members are a lot of parallels with being a shareholder. So if anybody here owns shares in Nortel, that's me, maybe a few other people admitting it. I still own shares in Nortel. So if you own shares in Nortel, or you happen to own shares in the local Canadian Tire dealer, you're a shareholder. Over here you have members. The shareholders of Nortel, when they get out and vote, elect the directors. The members of the charity elect the directors, and the directors appoint or elect the officers. So you can be a member of an organization, of a non-share capital corporation. You can be a director, and my second talk is going to deal with the directors, and you can be an officer. Everybody, now, members, they appoint the officers, they elect the directors, so it sort of goes down. That's why, of course, they're the most important. And they receive the financial statements. Okay, does anyone here a member of a charity? Hands up, anybody? Okay, now a lot of people, okay. Who knows, you know, how many members are there in the charity you're on the board of? You 2 ladies. Do you know how many members there are? 3 members of your charity, do you know how many? Okay, that's about what I thought, okay? Some people know. If it's a real small number, you know. If otherwise, you don't know how many members there are. And there's reason for that, typically, because a lot of charities have the members being the same as the directors, okay? Yours is because you have to have a minimum of 3 directors. So your charity has exactly the same people. The 2 hats. See, she's got it down. That's right. And it's probably, but yours, probably a lot of members, like dozens or hundreds, thousands of members, right? So that is, there's 2 models that you can have, and there's great debate about which is the most effective. In yours, you can call a members meeting. It's real easy and cheap to do because you get the same 3 people together. In yours, the cost of having a members meeting and sending the notices out across Ontario or the country is very, very substantial. In yours, when the members are the same as the directors, there's not really much chance of a palace coup. In yours, there's a real chance of a proxy fight, a quote-unquote proxy fight, and I've been involved in several of those where there's been disputes among the membership. Yours, when you have the same people, everybody thinks that's anti-democratic because you're not bringing in the people or the stakeholders or the supporters of the organization. And yours, I think, is very democratic. So when you're involved, that's one of the first questions you should look at for the charity is, do they have a broadly based membership, or are the members the same as the directors? Now, when you don't, there are classes of members. You can have different classes of members. And I'm involved with a client right now that, like so many charities, the government funding has tailed off, to put it mildly. And now they, of course, are gearing up from being an organization that was service-oriented now to one that's fundraising-oriented. And so they've got a couple of people on the board who are supposed to be involved in that, and they've come up with the idea of establishing rights so you can actually pay money to be a member. And if you pay $5,000, you're a gold member, and then you're, I guess, platinum's the best, or zinc, whatever the most expensive is, and all the way down to sort of a regular member. And they have a whole bunch of class of membership. And they came to me with this idea, and I explained the little story that I did about members, and I said, you're going to create some confusion. In fact, I did a little research and sent them a little memo of why I thought it would give some conclusion. However, as usually happens, they wisely decided that raising money was more important than making things legally easy for Pashby. And so I have asked to draft a bylaw which sets out these classes of membership. And in fact, there's a conference call Thursday morning at 8 a.m. because I said you have to do this by bylaw. You have to have members. Thank goodness they're members. There's just the 3, or in this case there's about 10. But they're the same people, so we can have the members meeting and the board meeting to pass the bylaw to establish these things. So once we get that sort of done and they get going, probably within a month, this corporation is going to be very confused, because there's going to be all kinds of people, maybe even some of you, are going to be asked to become a quote-unquote member of the organization. And the word member is not going to entitle you under these fancy new bylaws to any rights basically at all, nor probably do you expect to be, frankly. But the word member, they went to all kinds of groups, and the word member does in fact require that you're part of the team and you're got, you know, it actually is the perfect fundraising word, and they couldn't come up with any synonym, so we're going to do that. So that's the sort of thing that can happen. So keep an eye on the classes of membership. Another organization, which is not a charity, but it's a nonprofit organization, and it's quasi, you'd think it was a charity, and they have as their members big corporations, as well as sort of regular people like us. So they want to come up. They have Class A members now, which is sort of the big, you know, like let's say it'd be the banks if it was a financial service organization. And then they have the Class B members, which are sort of people corporations that deal with money issues. And then they have Class C members, which is regular individuals. And that's fine. Now they want to have subset of Class A, and they want to give everybody that is over like $1 million in assets gets 4 votes. So again, I've been trying to discourage them from getting involved in all of this. And again, I'm losing the battle, and there's not much law on any of this thing. So again, be aware of the membership. Next, the members elect the directors, and the directors approve the financial statements. I'm going to talk for a few minutes after the break on that. They should look at the budget. They elect the officers. They set policies. And from my perspective, the most important thing they do is they hire, fire, motivate, and remunerate the chief executive officer. And that's a hard thing for people to realize. So I had an annual meeting for a client charity on Friday where they came from across the country, and I had to subtly put on the board, on the agenda, because sometimes they want the lawyers to help with that, dealing with the performance of the executive director, and that's a real Delphic term if you're the executive director. And I didn't know whether he was looking for a raise or whether he thought he was going to be fired when I suggested he put that on the agenda, but that got taken care of. And then you have the officers. And the officers, you have to have a president. I recommend at least a president and a secretary to comply with what the banks want and everybody. And after that, you can have treasurers, vice presidents. The word executive director is used for a lot of charities. There's a big issue, and you'll start looking at it as to whether the executive director should or should not be the president, and whether that's the CEO. It's all it usually works its way through, but it's very important to talk to the person who is the person leading the organization. This meeting we had we had to have a few bylaw changes. This meeting we had on Friday, and one of them was to take the National Executive Director title to change it to Chief Executive Officer. Okay, so you can sort of look at that, and I had to pass that through the bylaw and explain that sort of to people. And I can see all the board some of whom knew it was coming, some of it trying to figure out whether that gave more status to the person who's running the organization or not. And they all sort of giggled and weaved and bobbed and said it was in lieu of a salary increase. And I looked at the person holding the position. I'm not sure, again, how he really wanted to respond to that. Any questions about those 3 statuses? Yes, sir.
If the executive director is a salaried employee,
Yes.
should he be an officer of the corporation?
Well, there's another. He should be an officer. Well, he can be an officer of the corporation. He probably should be. He was going to sign checks. Yeah. A director is different. Okay, we'll talk about that when we talk about directors. There's some common law suggests that he should not be, and it's probably not a good idea. But an officer, and then you have to look at which statute you're under, whether or not the president has to be a director. So it gets complicated. Yes, sir.
Taking from what you're saying, you could have non-voting class members,
Yes.
which you have to amend your letters patent and stuff like that.
Bylaws, usually do it by bylaws. Yeah. If your letters patent are silent on that, yeah. And that happens fairly regularly. Yes?
You mentioned that one way of keeping down the risk of a palace coup is to have a few members rather than many.
Yes.
Are there other ways you can do that as far as using proxies, for example? Can you put limits on the number of proxies a particular person can hold?
Well, we recently had, I recently had a, this is going to happen to you when you do pro bono work. And this was a client, I guess wasn't pro bono, but the amount of legal fees might as well have been. And they had really big problems, so, you know, from my perspective, it was almost pro bono. And they came, and I got a call. They had their annual meeting, people coming from all across the country last 2 weekends ago, I guess. They asked me to come to the annual meeting. I'm sort of glad I couldn't because I was going to be out of town. And I had to, but anyway, they had issues with proxies given to people, and then who were passing the proxies to other people. You know, and it just was, I could see I wasn't going to be at the meeting just as well, and I was trying to give them, sort of as a corporate lawyer, trying to give them some practical advice. And one of the ways I always try to do it is to try and find a way to avoid having to answer the question. Because there isn't, I know there isn't a lot of law on that sort of stuff, and you can go back to principles of agency and things like that. So anyway, they came up with another way, because this was the Friday of getting these key proxies, because I knew there was going to be a proxy discussion, and I knew I drafted new bylaws for them, and I got an email on the Monday from the executive director saying, Bill, your advice was very helpful. The bylaws passed, but our 2 other motions didn't pass. I was mostly interested in the bylaws. So those things, you just have to avoid those sort of things. But putting in your bylaws limits on proxies and all that stuff is, I mean, you know, that sounds like brass can more than your average charity. So I always try and keep it kind of simple if I can. Any other questions at that? No? I'm sorry? Yes, yeah. Yeah, well, it creates, yeah, that's right, yeah. Yeah, that's right. There's a lot of tricky things there. Okay, one of the things comes up here is that, is there anybody involved or know of a nonprofit charity that is not incorporated? Okay, well, I'm going to briefly touch, because you're going to find a lot. A lot of people have sort of started these organizations, and the question is, should we incorporate or not? That you're going to find, especially if you're doing the pro bono, because those are sort of startup organizations. You know, we're already, you know, a lot of people sort of have something going and then decide that, you know, it's going to go somewhere to move forward with that. If you're unincorporated, you're probably either a trust, and usually there has to be some trust documents. If they can't show you any trust documents, they're probably not a trust. Or you're what's called, and it's not a legal term, but we use it, called a voluntary association. And that's just any group. You know, if on your block you happen to get together to have a fireworks display on the 24th of May, and 3 people get together, whether or not you know it, you've probably created a voluntary association. And if something happens, then everybody's going to say, I wasn't involved, but it's going to come forward. And I was at a meeting earlier last week where there was a quote-unquote coalition. And this was a coalition dealing with injury prevention and safety. And they were putting 2 coalitions together, and I was sort of the guest speaker, gained pro bono. I got a nice lunch out of it. At a very nice place, and their issue was whether to put these 2 organizations together and whether they should incorporate or not. And so I thought I'd just give you the sort of the bare bones of that discussion. And if you're unincorporated association, you don't have any separate legal status. Okay? You're probably controlled by the people involved if there is a list of 3 members or 5 members. The ownership of any assets you have is uncertain. There are very large organizations which are unincorporated. You'd be very surprised, and I was, and I can't mention any names, but I've got 3, in the last 2 years, 3 clients who you would probably know the names that were unincorporated until last year, until they had this little discussion with them. And the liabilities for debts. Each member is jointly and severally liable for the debts and other obligations of the association. When you raise that with the people, forget about directors' duties. When you raise that with people, they start, like, people are picking up their pens right here because probably somebody may think they're involved in the local softball league that might or might not be incorporated. Their governing law is when you're incorporated, you have those statutes, corporate statutes, which help out. If you don't, you know, who knows? It's just sort of all over the place. And there's this very large organization that over 100 employees, existed for 25 years, that I just incorporated last year. And they had, you know, actually throughout my career, I'd done about 3 or 4, because they were clients of our firm. And 3 or 4 times I'd raised the issue and done a little research on it, brought out the same memo, redid it, updated it, and gave it to them. And the people involved finally decided to do that. Governance, one thing about governance, if you're a nonprofit organization, incorporated, you have some structure to it. That sometimes is good, because you can look up the law. If you don't, it's completely flexible. And so it's terrific flexibility, which is what the people like, the clients like, but the lawyers don't like, because they can't give them any advice. And there are some tax issues, which very nice for me to be able to leave those for Jim after the break. So if you decide to incorporate, you can incorporate in Ontario. You're going to incorporate federally or in Ontario. Everybody asks which. I know in that business organization class they talked about the differences between the two. Frankly, I can't remember, in doing this stuff for 10, 15 years, ever really becoming a big issue as to whether you should incorporate it. If you're a charity, you might want to incorporate federally so you can stay away from the public guardian trustee. That saves a little bit of time and effort and money, but it usually isn't an area. And if you're, I guess if you're incorporating the National Defense Association charity, then it's probably a federal. National defense sounds like a federal issue, and education sounds provincial, but most charities sort of cross the line, so that isn't really a big issue, I don't think. And you have to get a name clearance and all those things. It's well-published things how to do that. And one of the things you do have to do, though, is you have to have objects. And I've got several charity clients that are over 100 years old. Some of them have objects that I think are written in Old English, literally. Some of them, I can raise it with them, and it's very difficult to get somebody that runs an organization that's been 100 years old to try and want to tinker with some of the stuff that was over 100 years old. I mean, the longer you wait, the more difficult it is. And you can talk to them about ultra vires and all that stuff, and then they ask you how many people have ever gone to jail for that, and then you have to say, well, not many. And then, so very rarely, every once in a while, it's kind of neat actually to have to do something. Some of these organizations, if you get involved with, are special act corporations, and that creates, I've got a very large charity that's a special act corporation that we're having some fun with now, and they're amending their bylaws substantially in a couple of weeks, but I couldn't get them to do supplementary letters patent, even though I kind of pointed out that they're, actually, if you look at their objects from over 100 years ago, they're not politically correct, as you can imagine, in all kinds of ways. So you can do that. Any questions about incorporation? I mean, it's a procedure. You fill in the forms. I do a lot of incorporations of charities and nonprofits, and I do a lot of getting charitable status. And there's certain approaches to doing that which are better, and you try not to get in arguments with people, and sometimes you say too much and sometimes you say too little. We've had almost 100% success with Canadian ones. Sometimes we get Americans that want to establish charities up here, and they sort of have special things they may force us to do, which we tell them that the examiners aren't going to like, and they tell us to go ahead. There's some charities in the States that have got one that's got 4 house counsel on the charity, working full-time for the charity, so they're supposedly experts, and they're not really paying much attention to Canadian ways, and sometimes we're not successful in that. Well, if you're going to incorporate, one of the things that I ran across last week, I was thinking of this yesterday, was I was sitting in the backyard in the sunshine, spending a little bit of time preparing for today, and this came up. One of my charities is a school, and they always had on their, you can have directors ex officio, which means the principal of the school, or the head of the school, whatever his or her name is automatically a director, which makes some sense. And they also had the student leader was on the board. This was a high school. Now they sort of reminded me that none of the student leaders now were 18 years old. This sort of thing, where they went from 5 years of high school to 4 years. So we were probably putting on the board ex officio someone that didn't meet the requirement of Section 6 of the bylaws, and the statute said you had to be 18. So I had actually never thought of that. So it was one of the teachers sort of raised that, and I suspect they probably had people that maybe for years that were probably 17, turning 18 in their final year of school. One of the other things that comes up is conflict of interest. So who sits on a board here? Okay. Why did you join that board? I mean, make it up if you don't want to tell us the truth.
Depends on which one. One my family forced me to. Another is an artistic interest that I took that I appreciate.
Yeah, okay. There's a reason why everybody joins a board, right? And sometimes it's altruistic, and we like to think, for charities, we like to think it is. But if you look at the people I look at the people on the boards, the clients, that there's usually another reason. There's some hook in, right? They're interested in the art, right? And you're on this board, you're actually going to meet some artists, right? Or you're going to get some other benefits to that sort of stuff. So there's always a potential conflict of interest. And some of the things are because your kid's involved or your mother's got the disease or you want to learn more and things like that. So having a conflict of interest is a very natural sort of thing, or a potential conflict of interest. And you in fact want people that have somehow tied into they got some passion about the organization if it's a charity. I mean, that's what you really want involved in those things. So don't go to the first meeting and say, okay, everybody who's got a conflict of interest has to leave the room, because if you set the bar very high, you're going to have nobody there. So then you have to think about, what do we do about that? And if you have your proper bylaw, it's going to provide for some procedures for what to do in a conflict of interest. And if you look at the statutes, and then you can do something about it. Now, a conflict of interest arises when you act in more than one capacity. I mean, this lady's got the two hats. It's not a conflict of interest being a director and a member, but it's when you get involved in two things. And sometimes, there's a classic conflict of interest on two charities when you sit on one charity board and you also happen to be on a private foundation that gives money to that charity. In fact, that's why you're on there, because you gave a lot of money. Now they're going for fundraising, going back to you. I mean, that's why they want you there, is because you have that conflict. You might give some more money to them. And very often, if you're on a charity board and you happen to have a snow plowing business and you can sort of do it for free or give them some special services or do some things like that. And Terry talked a bit about conflict of interest for directors, and I'm going to talk about that again. But so it's a natural. What you have to do is you have to declare your interest, right? And then not benefit and pull yourself away. And I'm not going to spend a lot of time on that, but just don't frighten people off because there is a conflict of interest. Explain it, as long as everybody knows it. You're going to be, it can work out quite well, and I wouldn't be too worried about it. You have to make sure you don't make a lot of money and profit from it, but the lady that's on the charity foundation board and giving the money to the operating charity isn't really going to get a financial benefit from that, so don't be too worried about that. Nightmares. I'm going to read you a couple of situations that are really true, and this may fit for some of you. A broadly based organization followed the principle of many organizations permitting an unlimited number of members. It's your organization. In this organization, anybody who paid a $10 fee could become a member. So the organization did not keep a register of all those members, as the payments were small and they came in various times during the year. That happens, right? Just facts. Forget you can do it in computers. People just can't do it. Therefore, the organization could not follow the legal requirement of giving formal written notice of its annual meeting to all those members. They sent it out to everybody. They didn't get 100%. In most years, about 50 individuals, including the incumbent directors, their families, and past directors, paid the fee to become a member. In 1999, they had 200 individuals pay the fee and therefore entitled to become members. Unknown to the president and the board of directors, a group of 150 individuals who had paid the $10 fee and became members appeared at the annual meeting. They nominated their own slate of directors from the floor and easily outvoted the 50 loyal members who had showed up at the meeting to vote in favor of those the nominating committee had suggested. As a result, there was a complete change in the board of directors. The president's employment was terminated. The small group had in fact hijacked the organization. I happened to have been there as a lawyer for the organization, and one of the saddest things was that the new board, of course, fired the accountants, the lawyers, and everybody else, so they have a vested interest, and this was a paying client. That actually happened. I was at the meeting, and they bust people in, and it really can ruin the organization, I mean, notwithstanding some things. So there are ways to try and minimize those things, but be aware that if you don't keep track of all those things, you can do it. The second one, a provincial educational organization operated across Ontario, had chapters in several cities across the province. The executive director and the board of the organization had not contemplated problems which might arise with respect to the banking and financial matters. The chapter in Woodstock, I made that up, was quite independent and quite active and operated by a dynamic volunteer. You may have somebody, she was really making a difference. Each chapter had its own bank account, and to the surprise of his lawyer, i.e. me, who eventually became involved, the bank account was in the name of the Woodstock chapter rather than the organization. So it said ABC Woodstock chapter. An individual died leaving substantial money to the Woodstock chapter of the ABC Education Association, and it was deposited to the chapter's bank account. The Woodstock chapter decided to go its own way. This became known to the executive director of the Ontario organization, and steps were contemplated to try and stop the Woodstock chapter from pulling out. I was trying to do that for them, help them. It was discovered the name of the organization was trademarked by the organization, and therefore the Woodstock chapter could not use it. The result was the Woodstock chapter started out its own, incorporated under a different but somewhat similar name, and used the funds in the account and the bequest to finance activities. The organization lost a chapter, the money, and some good volunteers. Then other chapters wanted to do the same thing. So what happened here was that they opened a bank account in the wrong name. They'd never put the corporate documents in there. I wrote a nasty letter to the bank manager saying, you got to freeze this account. And he sort of wrote me back and said, prove that this name is in the name of your client. And of course, it had been open a long time before I was born. No, not but before I was involved, and there's no way we could prove it. So the bank manager sent a copy of this to the protagonist in Woodstock, and they sort of thumbed their nose at us, and they kept the money. So, and it was way more money than this organization had ever seen before. So it's not the sort of thing that you want to get involved in. A British Columbia-based social agency, and again, I could have said Oshawa, had a policy of encouraging participation in democracy, and one time had 72 directors. The quorum for a directors meeting set in the bylaws was a majority. We did a minute book review, and for 5 years, there had never been 37 directors present at a meeting. I mean, it was a real easy. The clerk that does these things for me said, Bill, this was the easiest one we ever had. Thus, the board had not properly met for 5 years, and all the actions taken by the chair, the executive director, and other officers had not been properly approved. Needless to say, they were happy that they asked us to do the bylaw review before somebody else discovered it, so we sort of coopered it all up, and with the passage of time, everybody will be fine. There is an exclusive independent school in Montreal had never elected appointed members. Remember you said to members? They had never had a member. The law says you have to. I went and talked to them. What do you mean, member? No, we don't. We have our annual meeting, and it's the annual meeting of directors. And nobody ever raised this. It's an independent school, and it had been around for a long time. They just never thought of that. So when you ask for the members, a school now follows a proper set of meetings and directors, and things happen. And this is sort of the last one, which is now it's state dated, but it really shows you how you should do your corporate checking initially. A hospital in southern Ontario was incorporated under a special act. The hospital did not realize that it was subject to the Corporations Information Act and had never filed annual returns listing directors and officers with the government. When the hospital was taking steps to arrange some bank financing, yours truly followed the usual practice of doing a corporate search. And when the clerk came back and said, we can't, I sent them back 3 or 4 times thinking the clerk was sort of going the wrong spot. In fact, we couldn't get a certificate of status, and there was some doubt as to whether the corporation had in fact existed for a period of time. So again, we found this out in advance, and we corrected things, and everything's gone kind of cool. So there are some things there. Those are some examples. So you're going to find when you get involved in the pro bono aspect, ask to see the minute book, ask to look at the letters patent. If they don't have any of those things, if you're giving advice, make sure that you've given them advice that they should get those things, because you want to get yourself off the hook, and those of us who insure all of us off the hook with respect to those things, and then help them with whatever you're doing. 6 things to remember. Firstly, 50% of the company's corporate records are going to be in bad shape. So if you're asking, you're getting asked, and if you're asked anywhere near that, if you're asking to help them with a lease, then you can help them with the lease, but make sure you don't have to give any advice with respect to these other things. Members are different from directors. Okay, we've talked to the 2 hats. Remember those differences. Conflicts of interest are natural. Then you just have to deal with them, so don't rule them all out. Bylaws should be updated every 5 to 6 years. And if you get an organization that doesn't have any bylaws, or the bylaws haven't been looked at by someone that knows something about non-share capital corporations for some time, then they should be, because they'll be out of date and they'll be doing some things. The law does change a little bit, certainly some procedures do. Directors and officers indemnity insurance presents tricky issues. I'm going to talk about that after the break, and Terry mentioned it, just be aware of that. Corporate law nightmares are common. Okay, it happens. In fact, I bet you if you, any of those boards you sit on right now, some of them got some corporate law nightmares out there, so you as a lawyer have some do the legal audit. And remember, I'm going to talk about later, but lawyers, if you're on those boards, you have a higher duty in the back than you do if anyone else because of the subjective test. Okay, any questions? Yes, ma'am.
I wanted to ask, Industry Canada has a model bylaw on the website for nonprofits.
Yep,
Can you just give us a review of that model?
it's okay, start with that. Yeah. I mean, you know, we of course, corporate lawyers can criticize all those things, but on a pro bono state, that's a good place to start. Yeah, but make sure the client goes through and understands some of it. Yeah. Anybody else? Good. Time for the break?
Time for the break?
Good.
Thank you, Bill, for that a little bit scary but very comprehensive presentation as well. I'd like to have a short break at this point. We're running a little behind, so why don't we take a 10-minute break and reconvene shortly after 11 o'clock. There are some of you that came in just a little bit after we started. I'd please ask you to fill in your application forms for volunteer lawyer service and hand them over to Lisa Kruji. Lisa, could you stand up, please? Lisa is our case coordinator, and you will be dealing with her extensively with VLS. Thank you very much.